All right, we'll call the next case, and it's 24-2944 Scott Hale versus Sleiman Enterprises. You'll let us know what you want for a rebuttal time, you can get going.
Yes, good morning, you all. 5 minutes for rebuttal, please. My name is Benjamin Stevens, and I represent the appellate, Scott Hale.
Appreciate you coming down from Pensacola.
I'm glad to have the invitation, so thank you. The trial court erred in rendering summary judgment in this case for 2 reasons. It should have found that Sleiman owed a duty to reasonably follow through with its arrangement with Domino's. When Domino's alerted Sleiman of the roof leak, Sleiman's responsibility under the arrangement was to investigate it. After all, they specifically prohibited anyone else from going on the rooftop. Once they investigated, they were to delegate the repair responsibilities to whomever needed to repair it. Second, the obvious danger doctrine does not foreclose Sleiman's liability in this case as a matter of law. This court should correct those 2 errors. I'm going to start with the duty argument. Sleiman's duty arose from 2 sources. First, Sleiman assumed the duty to investigate leaks and delegate repairs. It exclusively controlled the access to the rooftop and prohibited anyone else from going to the rooftop without, and this is quoting from the lease, without approval and participation from Sleiman. It had agreed that to provide a service. It assumed the responsibility to investigate leaks from the rooftop. And once
Council, didn't they investigate? They did nothing?
let me go over the factual sequence of the timing.
So they did something. They didn't just look the other way. Didn't they go out and inspect?
You're absolutely right. They did something. They did something hours after the accident. So Domino's alerted them. The water's on the floor. Domino's is alerting. We got a leaking problem. Our AC guy says it's an issue with the roof. What did they do? Nothing for 6 days. Then the accident on the morning. Then, oh, well, we got to go up and see what's going on with this roof. That's the order of things. So that I would.
Maybe I'm mistaken. It wasn't the testimony that it wasn't of the roof that was leaking, that was your client's, whatever the device was, that was not properly sealed?
Yes, that is absolutely the testimony. The question was it a roof issue? Was it penetrating the roof? Or was it coming in, intruding in another location, the vent? It turned out it was the vent. But I think it's
critical. Why does it matter whether they went on day 1 or day 2? It's your client's failure to keep the vent adequately sealed.
I think there's 2 reasons. Inspection precedes maintenance. No one knew where the roof was, where the intrusion was until the inspection. It was Sleiman who had the duty, because it exclusively controlled access to the roof, to perform the inspection. No one could know what needed to be repaired until we figured out what was the problem. And Domino's certainly did not have authority to go up onto the roof and repair the vent. First of all, because it didn't know what needed to be repaired. It was waiting for Sleiman to tell it what needed to be repaired.
They had no implied access. In other words, it's their vent. Their duty to maintain it. They had no implied access
No.
to inspect it.
No. The lease specifically said, and I would point to the lease and also the practice. The lease specifically said, no one is on the roof without express written permission from Sleiman. The second part is the practice. In the deposition, 30B6 deposition of the corporate representative of Sleiman, she spells it out very clearly. The process is this. Domino's tells us that there's a leak from the roof. We investigate it, and then if it turns out to be the vent, well, Domino's has to pay for it, or Domino's has to repair it. But we're going to approve and,
What does the lease say about who does the work? Doesn't it say that either landlord's contractor has to do the work or even the inspection? Is the lease silent as to who will do the inspection, other than the landlord has to approve it before anybody goes up there?
I think it is silent on the inspection, but the practice is, of course, that, and this is unequivocal, that the practice is Domino's alerts them of the loop.
Well, regardless of who goes up there to do the inspection, the lease very clearly says Domino's can't send anybody up there.
Absolutely. And in fact, that's what happened factually in this
So
case.
what happens if, a couple things. So what happens if Domino calls the landlord and says, hey, we have, there's like a leak in the roof, and that's all that's said. So landlord has no idea how bad it is, could just be a little drop coming down. I'm sure, you probably know I'm trying to figure out the scope of this duty here when it might activate. What's your position on how much information does the landlord need to have before this duty activates? I mean, do you agree that if you call and just say, hey, we have a little leak here and that's it, maybe there's not a duty then?
No, I would not agree with that.
So any amount of leak, one drop coming through the roof, duty.
Yes.
Okay.
I think the mitigating part is on the breach of the duty, right? The question then becomes, you have a duty to inspect, which is the inspection precedes the maintenance. You have a duty. Well, is it reasonable to just blow it off?
I mean, look, this is, if we're gonna write an opinion, we need to think about these things, right?
Yes.
It's our job to think about these things. So how does one drop of water, how would that be a foreseeable zone of risk? If you tell me, if I'm the landlord, you tell me, hey, the roof just leaked, it's a whole drop of water. That's it, it's just one drop? Yeah, just one drop, but it leaked through the roof. How is there a foreseeable zone of risk?
And I assume I'm trying to understand the question, because how I would immediately answer is that is a question for breach. That would be entirely.
Well, no, isn't there a foreseeability analysis for duty?
So that would be the McCain question. Is that where?
Correct.
Yeah, okay, great. So the way I view McCain is McCain looks at general risks, right?
Right.
If there's a foreseeable harm from a general risk.
And one drop of water, I mean, that's what I'm not suggesting what the answer is. I'm genuinely asking the question. One drop of water equals an increased foreseeable zone of risk?
Yes.
Okay.
In a general sense. And the reason why is because the one drop may become something else. We don't know what's going to happen. One drop may be indicative of a bigger problem. And I think the question, as McCain says, McCain is emphatic that duty simply opens the courthouse doors. This should not be a high bar that people need to get over. That what we need to then look at is on the breach of duty. Was it reasonable that when they get a call about one drop of water emanating from the roof or coming through the roof, was it reasonable for them not to immediately drop everything and send an inspector over there? I think they have a good argument at a trial that it wasn't. They didn't need to do that. They didn't breach the duty. The duty is a low threshold. It is simply the minimal threshold to get into the court.
And I guess that's my question is, one drop of water seems like it might be a low threshold. Why would one drop of water, and I understand, I don't think anybody called up the landlord here and said there's only one drop of water coming through the roof. I'm not saying that, but why is that not relevant to, I know the difference between duty and causation and the foreseeability analysis. I understand there's a difference, but there's a foreseeability analysis on both. And how does, for duty, we need to ask, how does this increase the foreseeable zone of risk? Correct? Do you agree with that?
Yes.
Okay. How would one drop of water, hey landlord, we have a drop of water that just came through the roof, and that's all the landlord knows. How does that increase, how would one drop of water increase the foreseeable zone of risk?
It's the failure to do the inspection, which would then precede the maintenance. The reason why is, I guess I would focus on two parts. It's the general risk, the general threat, the zone of risk, as you just said, that people are focused on in the McCain analysis. Frankly, this foreseeability issue under McCain, it's sometimes difficult to even think that there's any daylight between when you might have, when you'd have liability, because it was, not foreseeable in a causation sense versus a duty question. But McCain sets the bar for foreseeability under duty very, very low. General risk, is it possible? You know, I mean, these are the questions that McCain is addressing. And so, and because duty is simply a minimal threshold to get into the courthouse, courts should not be deciding foreseeability as a general matter, as a matter of law. It should be kicked to the jury under the Constitution.
Duty is determined as a matter of law. Counsel, is it not?
Duty is.
And so the foreseeability analysis for the duty element is a question of law, no?
Yes.
Okay.
I guess what I'm trying to say is that what does it mean to have, this is how I parse it out. Under McCain, they talk about the foreseeable risk, right?
The foreseeable zone of risk.
Zone of risk, thank you. The restatement, the third restatement on torts, removes foreseeability from this and actually has a long discussion about whether foreseeability should be even in the question of duty. And I thought about this, and I thought, well, you know, foreseeable zone of risk. Can you have a risk that's not foreseeable? It seems like foreseeability in that sense is not doing much work. If there's a risk, that's enough.
Well, are you suggesting that we should follow the third restatement instead of McCain?
No, I'm saying that I think the McCain, a lot of this discussion that comes from McCain, of which of course you're bound, not the third restatement. A lot of this is focused on this question of foreseeability, which becomes incredibly difficult for lower courts to figure out. And that focusing simply on the risk would make more sense.
How about the second issue, counsel?
Yeah, the second issue is the obvious danger doctrine did not foreclose liability. First of all, as a question of duty, it can foreclose a duty to warn. But this court has been emphatic that it does not foreclose a duty to maintain or inspect. And I would point the court to the Middleton case. Aaron, you know, there's a litany of cases from this district. The second, the inspection, and so when we talk about the application of the obvious danger doctrine in a maintenance question, it's moved to breach. That's where we're talking, because you have it doesn't eliminate the duty, it bears on the breach. And the breach is, of course, a jury question. And the jury question here that the trial court did not ask, and thus erred as a matter of law, the jury question here is whether Sleiman should anticipate the harm notwithstanding the obviousness of the danger. That was a question that was not asked below. When it simply said,
does Sleiman have to have actual or constructive notice of the danger here, the leak?
yes.
And on September 21st, Mr. Hale, if you'd asked him before he fell, he would have said it's not leaking anymore, all the water's in the trash cans, correct?
It has to have knowledge of the risk.
But if Sleiman knew, Hale would have been the most knowledgeable person of whatever the actors were as far as we know, correct?
That seems right.
And if you had asked Hale before he went by the oven and fell down, is it still leaking? He would have said no. How does that translate into actual or constructive notice on the part of the landlord?
I think to me, it's entangling two different ideas. One is the constructive knowledge actual or constructive knowledge that the defendant would have to have. The second is the application of the obvious danger doctrine. The first is governed by Owens, that a condition that regularly reoccurs, a person has constructive knowledge of. This was a regular circumstance. All Sleiman knew was that Domino saying it's been raining into our restaurant, please help. It now has constructive knowledge of the risk. That's on the question of the knowledge for liability. And again, I think knowledge for liability in this case would then fall under breach, not duty. But switching then to the obvious danger, the question is presently, and And I think this is where the court got it wrong. The court was talking about a water leak, which would be important for constructive knowledge under breach, instead of water on the floor. The danger, if there was one, would be water on the floor. But Mr. Hale comes into the restaurant, doesn't see any water. It's a sunny day. Seems like it's all dried up. There's no obvious danger in that sense. And I think that is still compatible and with not the constructive knowledge that Sleiman still had, that there was leaking water as opposed to water on the floor.
You're into your rebuttal time, it's your time, you can do what you wish.
I'll reserve, thank you.
Good morning, may it please the court, Jack Ryder on behalf of the Appellate Sleiman Enterprises.
And we thank you for coming up from Miami.
Good to be here, Your Honor, thank you. And I'll start by saying here that summary judgment was completely appropriate, and Judge Anderson, the trial judge, wrote a meticulous order analyzing these issues. And as the court has already noted, Judge Eisnagel, that the fact is that the question of duty is always a question of law. And the question of law is to be established and evaluated and can be adjudicated at the summary judgment stage. Here, the issue of who owes a legal duty does not hinge on the ownership of the property, but who is in control of the specific property at issue. As the First District Court of Appeal explained in Walmart versus McDonald, the duty to protect third persons from injuries on the premises rests not on legal ownership of the premises, but on the rights of possession, custody, and control. It is undisputed in this case, not only from the affidavit of Mr. Barber, but also by the parties' joint stipulation that the leak at issue was coming from this hood vent. That's the technical term.
Well, we know that now.
Yes.
Nobody knew that until didn't someone need to inspect the roof to discover that?
Well, so here's the issue with that, Your Honor. The answer is yes, that needed to be inspected to find that out. But here's the issue, as it pertains to, and this goes deeply into this notion of who is in control of this specific piece of property that was the cause of this issue. And the lease, which again, both Judge Anderson and this court can examine as a matter of law, is extremely clear in how it goes through this process in terms of describing who was responsible for maintaining the hood vent. Now, and the reason this is critical, because it's not just about inspection, it's also about maintenance. Let me go through it briefly. Section 12A specifically required that the tenant had the obligation to maintain anything involving HVAC equipment, and it's maintained, repair, or replace. And this included ventilation ducts and fans. The ventilation.
And were they allowed to go onto the roof without permission?
No, they have to get approval. But there's no evidence in this record that that approval was ever withheld. And I believe that that's a significant issue, and here's why.
Who was approval of sought?
Or it's neither sought nor withheld. In other words, there's no evidence that it was requested or withheld.
Is it required that it be requested? Did the landlord grant permission to go on the roof?
Well, in other words, the lease does say, and I want to be clear about this, what the lease says is that the repairs to be done, any alterations or repairs, needed to be done with approval. It also says that going on the roof to do anything would require approval. But the lease, this goes back to the point I was making about the duty to maintain. If there's an obligation to maintain, then the tenant who has the duty to maintain the hood vent could have asked for permission to go and re-examine this hood vent to make sure that it was being maintained properly.
Nobody had any idea that it was the hood vent. It could have just been any other component on the roof.
But here's the problem, Your Honor, is that you're right. We didn't know that until we sent somebody, and we sent somebody when it was brought to our attention.
7 days after it was brought to you.
Well, I understand the timeline, Your Honor. What I mean is that we did it once it was told to us. Yes, it didn't happen, it didn't happen that same day.
Whether 7 days is too long or not, it's a different question.
Sir, go ahead.
Does the lease not say Domino's shall not cause or permit anyone to enter upon or place anything on the roof of the premises?
Without approval.
Correct.
Right.
So, did the landlord grant approval? Did the landlord say, hey, you're good, go check it, go inspect it, have somebody inspect it?
So the record doesn't reflect that there was a request to do that. What the record reflects is that the tenant said, hey, there's a leak. And the landlord said, all right, we'll go check it out, we'll send somebody. But as it's been established by this record, this wasn't a flood that had come in, this was a sort of an on and off leak. It wasn't even clear how much. We did not know if it was a drop of water, as Your Honor discussed with my opposing counsel, or if it was a flood. You know, in other words, the tenant was in complete control. And we took direction in the sense that the tenant advises of this leak, and we said, okay, we'll send somebody. But keep in mind also, Your Honor, that when the tenant first observed the leak, they called their own AC person. And as Your Honor will recall from the record, it was the AC person that said, oh, I think this is coming from the roof. So there was, in between the time of the leak, and I can check the timeline on exactly when that happened, because there was in between the time.
Well, the relevant timeline is when the landlord knew about it versus when the accident happened, probably, right? But I guess the question I have is, if you said, hey, great, you told us that there's a leak in the roof, we'll have send somebody up to check on it. Why is that not enough for Domino's to say, well, we don't have permission to go. He says we can't go up there and inspect. Landlord didn't tell us to go do it. Landlord said they would have somebody do it.
So when you say why is that not enough, here's why. The question of timing, in other words, you're asking if it's a question of timing.
No, I'm not talking about timing. I'm talking about the authority to go up and inspect.
Well, I guess the issue here was this. You were right that at the time of the leak, nobody knew where it was coming from. And I'm looking back at the timeline that I have written down in front of me, because there's several dates that go into this. And Mr. Hale notices the water on September 13th. He notices the water again on September 15th. We are told we've had water leaking in. I'll read the quote. We've had a lot of water leaking in through the roof. Our AC guy says it's a roof issue. Can you please have a roofer take a look? Then the leak continues. Then the leak stops. Now, it is correct. It took a few days for us to send this person out. That's true. Once we send Mr. Barber out, or we send our person, it's established that, oh, this is a leak that's coming from the hood vent. It's not from the roof. So the only reason why that's so critical, Your Honor, is this is not a case where, for example, the tenant called and said, hey, there's water coming in. Maybe we go up onto the roof and inspect it ourselves. There's nothing in this record that suggests that. And this is why I believe the issue of was the request to go on the roof either asked for or withheld? And the answer is the record doesn't suggest that. I'm not aware of anywhere in this record where the tenant said, hey, can we go up? And we said no. I think it was more of, hey, there's a leak on the roof, and our safe.
So your argument is just there's no duty because they didn't ask to go up there.
That's correct. In other words, the duty.
But the landlord said, okay, we'll go up, we'll have somebody go check it.
And we did, and once we did.
Hold on, that's not the point. The point is that you landlord said, not you, landlord.
No, understood.
Landlord said, we'll go check on it. How is that not duty right there?
So when you say how is that not a duty, the answer is it's an undertaking to go inspect the roof. And again, I respectfully submit that whether it was done 6 days later or whether it wasn't is irrelevant, Your Honor.
It's irrelevant to the duty.
That's correct. It's irrelevant to the scope of duty.
Which is why let's not talk about the 6 days anymore, just talk about the duty.
So the reason why it's irrelevant to the duty is because the duty to maintain the property that was causing the leak, the duty to maintain it, occurred.
They couldn't get to it. They didn't know the vent was what it was. First of all, and if they did, they couldn't get to it because the lease says they can't go up there. And when they reported it to landlord said, we'll take care of it. We'll go up, we'll send someone, right? At this point, they don't know it's the vent. And even if they did know it's the vent, they couldn't just go up there. When the landlord says, we'll take care of it, what does a reasonable person think? They don't think that, oh, well, we have permission to go.
So, Your Honor, the complexity of the duty here, and the reason why I say the complexity, the reason why the duty, I believe there was no duty here, is because the obligation to maintain the hood vent. There was an obligation to maintain, and that's where I keep coming back to. At the restaurant rider.
Can I ask you a question, just factual?
Sure.
The summary judgment facts. This vent, and I'm trying to envision it, it's in the roof, isn't it?
It is.
Okay, so you've got the vent, it's a mechanical piece. But then I guess there's flashing around it, or something to keep the water from going in through the vent?
It had like a caulk, like a sealant.
Okay. So it was in the end, it's purely a vent maintenance issue and not maintaining the seal of the vent on the roof.
It was the seal of the vent. In other words, it was the vent, but not the roof. It had nothing to do with the rooftop. It was a separate, they called
The
it.
vent wasn't properly sealed.
Correct.
Counsel, let me ask you this. What do we make of Mr. Malone, or Maloney, however you pronounce his name? His testimony that the standard procedure was the tenant would report if they thought there was a roof leak, and then Sleiman would then take it from there. And the answer for Mr. Malone was correct. Why isn't that the duty, the undertaking duty, or
Sure.
again, the custom and practice that defines how the roof leaks were dealt with? Why isn't that a duty?
So I'll start from the fact that the duty is defined by the lease agreement and parole evidence cannot overcome or alter. As Judge Anderson noted, the parole evidence cannot modify the unambiguous terms of this lease. So I want to start by talking about how this lease establishes the duty. The lease makes clear that maintaining the hood vent was the responsibility of the tenant, maintaining. And they had a duty to maintain it quarterly. So,
And if they wanted to, they could call the landlord and say, hey, we want to go up there, do our
Exactly.
quarterly inspection, and the lease says, you use our contractor.
to repair, not to inspect,
Okay.
just to be clear. So why that matters, respectfully, is it's one thing to say, oh, we have a leak, and the property owner says, okay, well, we will get to sending someone out. We'll do it. We'll go take a look at it, right? But the duty to maintain, to prevent the leak from even occurring in the first instance, fell on the tenant. And that duty included requesting permission, say, hey, we want to go and do our quarterly inspection, and therefore we're asking permission to send an inspector up there. If there had been evidence in this record that they had fulfilled their obligation to maintain, and by the way, that's found specifically in section 4G of this, where it talks about roof access at tenant's expense, and it says the roof access, it's a combination. It's the restaurant rider, which is paragraph 3, which is at record at 113, where they talk about maintaining the rooftop exhaust fans in good working order at all times. So my point is that if you have, as a tenant in possession of property, the duty to maintain, and once again, they had said, hey, property owner, we want to maintain this property, and we said, absolutely not, you cannot go up there, then I think we'd be having a different conversation. Because then it would have been that we have assumed a duty that was inconsistent with what is clear in the documents that govern the relationship between the parties.
Okay, so if it turned out that it wasn't the vent, the seal on the vent to be precise, it was a shingle on the roof was damaged and water was flowing through the shingle, and that was and those aren't the facts here.
Correct.
But if they were in this case, then landlord has a duty.
Different issue, Your Honor.
Landlord has a duty, yes or no?
Yes.
Okay, so I see. So because, your argument is because plaintiff had a duty, this is your argument, I just want to confirm. Plaintiff had a duty to maintain the vent, that perhaps eliminates or changes your client's duty to inspect and maintain the roof.
Eliminates, Your Honor.
Okay.
Just like in any circumstance, when a tenant is in possession of property, it's the possession, especially in a commercial situation, it's the possession of property which governs who has the duty to individuals who are within the property. And as I approach the end of my time, I'd like to switch also to this notion of the concepts of foreseeable zones of risks and open and obvious and all those sorts of things.
Well,
go ahead.
The trial judge said that even if there is a duty, summary judgment is nonetheless appropriate. And how do you defend that?
Well, I defend that here because of the open and obvious doctrine.
Because the manager here, he's the one who slipped and fell. He put the trash cans out, there's water coming down, I don't know whether it's a drip, or there's a lot. I mean, how often he has to change the trash cans, I don't know what the record says. But at some point, there's no more water coming down, he moves the trash cans away. I guess within a short period of time, that same day, he slips and falls on the water. Is that the facts?
It is, Your Honor. And in other words, and again, the timeline is important, I believe, because you have an individual on the property. He's the manager. He observes water leaking into the restaurant, and he takes, trash cans and he puts them under the water. This goes on for a few days, and he puts the trash cans in on September 13th through 21st. Then it's a sunny day, the water stops. There's no, right, so this goes back, I think it was Judge Edwards, you were discussing with my opposing counsel, this notion that, well, how could anybody know that there was even a zone of risk when there was no water on that day? I mean, as it turned out, the day Mr. Hale slipped, if you had asked him, he would have said, there is no water, there is no risk.
Which kills the open and obvious defense, though, doesn't it?
Yes and no. It doesn't kill it, Your Honor. What it does is it gives us a bit of a different vantage point, and I'll explain why. It completely supports summary judgment, and here's why. It doesn't undermine the integrity of our position because the zone of risk and the fact that whether or not it was foreseeable was completely within Mr. Hale's understanding. I mean, he was the person there. He was inside the restaurant. He had information. He had knowledge about this risk, water on the floor. I mean, it would be no different, I would respectfully submit, to somebody who dug a hole and then put a piece of plywood over it, but then removed the plywood and then fell in the hole that they had dug. It's not different. It's a situation where not only did he foresee the risk, he really created the risk because he knew that the water was coming in. And it is, generally speaking, this notion goes to the issue of a duty to warn, but there is a point, and case law supports the notion that a risk can be so open and obvious that it does, in fact, eliminate the duty to protect. And now, yes.
The foreseeability issue, I mean, assuming there's a duty and it's breached, and this is sort of an odd set of facts because the water is dripping down, there's trash cans and it's moved away. So doesn't that foreseeability issue about what happened to the manager on that particular day become a jury question? Assuming there's a duty. I know you don't agree with that.
I don't agree with that. But it'll allow me to answer Judge Edwards, the second part, Judge Edwards, of your question, and I'll answer both.
Sure.
So I was getting to Judge Edwards. You said, doesn't it, kill the open obvious? And the answer is no. What it does is it reinforces it, because it reinforces the fact that the best person to have knowledge of whether or not there was a foreseeable zone of risk was Mr. Hale. He was in the restaurant. He sees water. He puts trash cans. He knows there's water. Nobody told him that anything had been repaired. So for some reason that only he would know, he moves the trash cans. Now, to him, that risk was open and obvious, and I believe he even created the risk or exacerbated it by taking what was a remedy and then taking it away. But the reason it reinforces the argument in terms of summary judgment is because, as you noted, if Mr. Hale believed there was no longer a zone of risk, then there's certainly no way for the property owner to have knowledge of the fact that there was water on the ground at that moment.
Doesn't it go to comparative fault?
I don't think so here, Your Honor, because ordinarily, the comparative fault would be if this was a classic transitory foreign substance type case. It's really off the beaten path in a way, because this wasn't a puddle of water appeared and we didn't get to it in time. This is, there was water, then there wasn't. There was water, then there wasn't. And Mr. Hale was controlling the trash can. So to him, it was open and obvious. And why this is not a question for a jury, Your Honor, in terms of foreseeability, is because, well, and first of all, I would respectfully submit you never get there because of the duty issue. But in terms of foreseeability, there was no way for the property owner to foresee that Mr. Hale would remove the remedy that he had applied in order to prevent the water from populating on the floor. That was completely unforeseeable. He created a zone of risk that was not reasonably foreseeable to the property owner. And there was no way that we could have known that an individual who was inside the property, who was controlling the water, would then eliminate that remedy.
So was that water that he slipped in was being caught by a bucket or garbage can before, or is that something you're assuming?
We are drawing some inferences here because, quite frankly, we don't know where the water came from. It was a sunny day.
But that's my issue with he dug the hole and put the plywood over. The hole was dug by the water coming down. Whether it was being caught by that trash can or not, we don't really know, do we?
Your Honor, we don't fully know that. We know a glass of water spilled that day. We don't know because even Mr. Hale said it was a sunny day. There's nothing in this record that suggests that on that sunny day.
Would that be a jury question, whether it was a glass of water or the roof?
But there was no evidence at summary judgment.
On the open and obvious, though. Come on. Your argument would be pretty strong if I think, maybe, perhaps, if a plaintiff said, hey, we don't need these garbage cans here. There's still water all over the floor. But, man, these things are in the way. I'm going to put them outside. That's not what happened. Plaintiff looks around, no water on the floor is dry. Says, we don't need the garbage cans today. And then, the record's not entirely clear, but then goes by the oven, I guess, and there is water still there, right? So, don't you think your argument on open and obvious would be a whole lot better if the testimony was, yeah, there was water all over the floor, but I put the cans outside because they were in my way?
I think it would be better, but I don't think it undermines the strength of the position where we're at now, because at the time, and this goes back to why it's not a jury question, at the summary judgment stage, it's incumbent upon the party opposing summary judgment to come forward with evidence to support a disputed issue of fact. And I don't see it here, respectfully. I don't see where they came in to establish a disputed issue of fact as to whether or not it was or was not foreseeable, or whether or not the water did or did not come from. Yes, we assumed it was water that was left over from the hood vent, but the bottom line is none of that changes the fact that Mr. Hale, they've argued that it came from the hood vent. That's why they're here. That's why they brought their lawsuit. But our position was, once he took ownership and control by putting those trash cans and then decided to remove them, it created the risk.
I have one more question on duty.
Yes, sir.
On the duty question, what do we do with the whole generalized versus specific, right? There's a different type of foreseeability for duty than for causation, right?
I agree with that.
So why isn't sort of when you talk about, well, look, had it been the shingle that was damaged and water was flowing through, yeah, there'd be a duty. But because it turned out to be the vent where water was flowing in, no duty. That seems pretty specific. And specific analysis has no place in the duty foreseeability question. So help me out here. On specific versus general, right?
Yeah, but Your Honor, I respectfully, I don't agree with the premise that you just put out there because maybe I'm seeing it a little bit differently, but you say that the specific issue has no place here. You just phrased it away. You said the specific
on duty, the question is there a generalized increased foreseeable zone of risk? And it's a generalized zone of risk. Am I wrong? It's not the specific thing that happened. It's a generalized zone of risk. Am I not?
I understand. Well, I understand the question, but I don't agree with it here because when you're talking about
I'm just so you don't. Okay, go ahead. You don't agree with what I just said?
No, I agree that that's a generally accepted principle of law.
Okay.
But why it doesn't apply here is because the lease agreement dictates who had responsibility for what. It's the lease agreement that dictates who had the duty to maintain the specific piece of property that resulted in the leak, and that's why. The idea of a general scope of risk, a general duty, that's something you find in a property owner to an invitee. A property owner has a general duty to an invitee. In a commercial property, when you've got a lease agreement that dictates that the tenant controls and maintains the duct.
Okay, it's the lease. I got you. I understand your argument.
Thank you, Your Honor. I asked this court to affirm it.
And you're saying that unless the tenant had requested the opportunity to go up on not to go up on the roof, but to have somebody go up on the roof, and you had refused permission, then the landlord's off the hook.
That's our position, Your Honor. I ask again this court affirm. Thank you.
Stephen, if you need a couple more minutes, we'll give them to you, but I'll wait and see how you do, okay?
That sounds fair. Thank you, Your Honor. I'd like to maybe just start off where we were. This question of inspection and maintenance and how Sleiman was in charge of maintenance, Domino's was in charge of maintenance of the vent, and Sleiman was in charge of inspection. And it seems like my friend on the other side wants to fully divorce those two concepts. The reality is inspection precedes the maintenance. We don't know what needs to be maintained, what needs to be corrected, until Sleiman goes up there and takes a look. And it was only happenstance.
But in terms of having an obligation to maintain things, you don't wait till it breaks necessarily to see if it needs to be maintained, do you?
There's certainly an argument to be there, but I would say Domino's didn't. Domino's said, hey, listen, we called our AC guy. We were trying to find out the source of the leak.
I think by the time it's leaking and the AC guy's looking around, there's a problem. There's a difference between trying to fix a problem and properly maintaining things.
Fair enough.
And as a passenger on airplanes, I like the idea of people maintaining things before they break.
Yes, absolutely.
So there's kind of, there's a difference here. I understand what you're talking about, and I follow you on that, but in terms of, your opponent is arguing that it was your obligation to maintain it. Basically, had Domino's maintained it with permission from them and with the proper people, then it never would have leaked, and therefore the fact that it leaked is all on Domino's. I mean, that's what I hear him saying.
Yes. Is there a prospect when this goes back to the trial court that there's going to be a Fabre defense? Is that, well, Domino's has something.
It's an apportionment of.
Yeah, I mean, listen, we don't know exactly what's going to happen, and, I don't know if this court is going to foreclose that. So that's where that should be taken up. But as far as the duty, it just can't be that it happenstance happened, that, well, it's the vent and it's not the roof, so now all of a sudden, proof no duty. Because the duty was to inspect. That's what the arrangement was with Domino's. We will check it out. Domino's told them we think it's a roof issue. That's why Domino's didn't ask to go up and repair the vent. They thought it was a roof issue.
The duty to inspect arose more out of the undertaking rather than the lease?
Absolutely, and I think that was a question on the parole evidence that my friend on the other side was talking about. Clay Electric talks about how the contract is but one facet of the undertaking. And the other parts are essentially the arrangement and the agreements between the parties. And in this case, Sleiman said, you got an issue with the roof, let us know, we'll send someone up. That's the proper procedure. That's what was happening, and different than what happened in Bovis, but that's what happened here. And I think the other critical part about Clay Electric is it talks about how this does not bind third parties. Hale was a third party. And so, the contract and the undertaking, I guess what I'm saying is we don't need to look directly and only at the contract. We can look at other
Both
parties'
parties' conduct can give rise to a duty, correct?
Right.
I mean, that doesn't mean that the lease is modified. It just means that some conduct in combination with the lease creates a duty potentially.
Absolutely. And if we had a breach of contract, we'd be looking at the lease exclusively. So, Your Honor, I'd also like to address, you asked a doozy of a question, what about one drop of water?
Well, your answer should have been, well, Judge, the record reflects that we told the landlord that it was a, quote, lot of water leaking. That's what your answer should have been.
Yes, absolutely. I understood your question to be more of a hypothetical.
Yeah, and it was.
Let me address that specifically, because I was thinking about that. I was thinking about the Middleton case, in which, I guess it's open and obvious question, and I wanted to emphasize that Middleton said, we have cracks and deteriorated sidewalk. There's no duty to warn. That's gone because it's open and obvious, but there's still a duty to maintain. That can never be taken away, even if it's open and obvious. We take care of that issue, the liability issue on the breach side. But back to the question, and I'm using that as an example, the sidewalk. Well, okay, we have a duty to maintain the sidewalk. Let's pretend you're a landowner or you're a restaurant, duty to maintain. Well, there's only a fine crack in the sidewalk. Is there still a duty? Well, yes. There's a minuscule. Yes, there's still a duty, because that is what opens the courthouse doors to the question of, was the defendant acting reasonably? Was there a breach? And so in that sense, I just wanted to emphasize how there is a duty, even a hypothetical question.
Go ahead.
Just one quick question. If this is a situation in which there's water on the floor, and there's various items, it could be the air conditioning system, it could be a hot water heater, it could be a roof leak, and it turns out that it wasn't the roof, but your client was responsible for maintaining the hot water heater, the air conditioning system, or that. Is it sort of a harmless error analysis? Yeah, they had to do it, they didn't come out quickly enough. But in the end, it wasn't a roof issue, so liability can't flow from that, so to speak.
But liability flows not from the maintenance of the roof, but from the lack of inspection.
Well, to me, that's almost like a breach of contract issue. You should have made a request, and if they didn't abide by the lease agreement, give approval, that's on them. And that's a contract issue, not a tort issue. But this is a tort case.
The tort case is from the employee, not from the contract, not from one of the contracting parties. So this is a tort case.
Right.
And the undertaking that Sleiman agreed to with the arrangement with Domino's is You let us know if there's a roof issue, we'll go inspect. If it turns out to be your vent, well, Domino's, you're gonna have to repair that.
Is there workers' comp here?
I believe there was, yes. But obviously, this doesn't apply in this context.
I have a follow-up to that one. So, let's say, to follow up on Judge Makar's question, the water heater, Domino's has full access to. The water heater is what's actually leaking. You think it's the roof, and so you call the landlord and say, hey, we think we must have a roof leak. Can you please inspect it? They say, yeah, sure, we'll come out and inspect it. The accident happens. Domino's, let's say, had the ability the entire time to discover the real leak because they were not restricted. They could have gotten to the water heater, they could have discovered it, but they didn't. They kind of sat on their hands because they were like, oh, it's probably a roof leak, right? No duty then, right? No duty at all by the landlord.
I would say duty, but the case, there's no liability because of lack of causation.
Okay.
And of course, this case is different because the two sources, the rooftop
So you're saying
and the vent are co-located.
You get in the courthouse doors, but you'd have no chance on causation.
It seems very difficult.
Okay.
Well, you didn't inspect it, well, okay, we didn't inspect it, but that was the
That's
source of the
irrelevant.
leak and you guys could have done it
Yeah.
all the way. Yeah, exactly. I think the causation problem would be the issue in that case, not.
Okay.
We requested the court reverse and remand for a jury trial. Thank you.
All right, thank you very much. And we appreciate council coming from so far to be here, and we greatly appreciate having an audience. We're used to having about 2 people watch these things. I don't know if y'all have any questions or comments or anything for us or for council, or if not, we'll be in recess, or the students